Good day. I'm Mary Grace Galanida from BSHM3A, and today I am going to discuss the Chapter 7 of the legal aspects in hospitality and tourism industry, the laws in regulating transportation establishments. The Philippines is a popular tourist destination known for its friendly people and diverse attractions. However, safety and security issues pose a challenge to promoting tourism. While Filipinos excel in transportation and travel professions, such as seafarers and pilots, the country has also experienced transportation disasters. So this chapter will discuss the laws that impact the transportation sector, which is important for the study of tourism. So here are our learning objectives for today's discussion. So first, identify the laws affecting the transportation sector, identify the rights of passengers of commercial transportation, and explain the relevance of these laws to the promotion of tourism in the country. So now let's proceed to the first law, the laws on common carriers. So the primary law that governs common carriers is the Civil Code of the Philippines as clearly implied from Article 1766 thereof, which states that in all matters not regulated by this code, the rights and obligations of common carriers shall be governed by the Code of Commerce and special laws. So in this Article 1732, common carriers are persons, corporations, firms, or associations engaged in the business or carrying or transporting passengers or goods or both by land, water, or air for compensation, offering their services to the public. So let's say you book a flight with a commercial airline to travel to different city. The airline is considered a common carrier because they transport passengers for a fee and offer their services to the public. As a common carrier, the airline is responsible for ensuring your safety during the flight and delivering you to your destination. So if there are any issues or incidents during the journey, the law protects your rights as a passenger and holds the airline accountable for any damages or losses. And now let's talk about the responsibility of common carriers. In Article 1733, common carriers from the nature of their business and for reason of public policy are bound to observe extraordinary diligence in the vigilance over the goods and for the safety of the passengers transported by them, according to all circumstances of each case. Like for example, imagine you take a taxi to the airport. According to Article 1733, the taxi driver, as common carrier, is obligated to exercise extraordinary diligence in ensuring your safety during the ride. So this includes following traffic rules, driving responsibly, and maintaining the vehicle in good condition. Next, we have in Article 1755, a common carrier is bound to carry the passenger safely as far as human care and foresight can provide, using the utmost diligence of every cautious person, with due regard for all the circumstances. So for example, suppose you book a cruise vacation. The cruise ship company, as a common carrier, must ensure your safety throughout the journey. So, nag-involve si Joe providing well-trained staff, conducting safety drills, and maintaining the ship's equipment to prevent accident or incident. However, in Article 1756, in case of death of or injuries to passengers, common carriers are presumed to have at fault or to have acted negligently, unless they prove that they observe extraordinary diligence as prescribed in Articles 1733 and 1755. So for example, if a passenger sustains injury while traveling on a bus, the bus company is initially presumed to be the responsible for the incident. However, the company can defend itself by providing evidence that it took all necessary precautions and exercised the required level of care and diligence to ensure passenger safety. Now, in Article 1757, the responsibility of a common carrier for the safety of passenger as required in Articles 1733 and 1755 cannot be dispensed with or lessened by stipulation, by posting of notices, by statements on tickets, or otherwise. So for example, an airline cannot escape its responsibility for passenger safety by including a disclaimer in the ticket stating that it is not liable for any accidents or injuries. So the airline is still legally obligated to exercise extraordinary diligence in ensuring the safety of its passengers. So now let's proceed to the liabilities of common carriers for the acts of employees and strangers. So in Article 1759, common carriers are liable for the death or injuries to passengers through the negligence or willful acts of the former's employees. So although such employees may have acted beyond the scope of their authority or in violation of the orders of the common carriers. So for example, let's say you take a train operated by a common carrier. If a train conductor who is an employee of the carrier acts negligently and fails to ensure passenger safety, resulting in injuries to passengers, the carrier is held liable for the conductor's action, even if the carrier had taken proper precautions in hiring and supervising the conductor. They are still responsible for the consequences of the conductor's negligence. So this liability extends to situations where the actions of strangers cannot employed by carrier caused harm to passengers. So the carrier remains responsible for the safety of passengers regardless of whether the harm was caused by their employees or outsiders. So let's jump to the nature of airline, bus, and shipping tickets. So the best evidence of a contract of carriage is the passage ticket. Under our jurisprudence, an airline, bus, or shipping ticket is a contract of adhesion considering that all the provisions thereof are prepared and drafted only by the carrier. The only participation left of the other party is to affix his signature thereto. In such situation, the Supreme Court ruled that the term thereof must be interpreted against the party who drafted the same, in this case, the carrier. So for example, when you purchase an airline ticket online, the terms and conditions of the ticket are already predetermined by the airline. As a passenger, your only option is to agree to those terms by signing or accepting the ticket. So if there is any disagreement or confusion about the ticket's provision, the court will interpret them in favor of the passenger, as the airline is responsible for drafting the contract. Now next is the registration of aircraft. So only aircraft owned by or leased to a citizen or citizen of the Philippines and which are not registered under the laws of any foreign country may be eligible for registration. So for example, if a Filipino citizen purchases a new private jet and wants to register it in the Philippines, they can do so because they meet the requirement of being the owner and a citizen of the country. However, if the same person already owns an aircraft that is registered in another country, they would not be eligible to register it in the Philippines. And next is the seatbelt law. The seatbelt law was enacted to secure and safeguard its citizenry, particularly the passengers and the drivers of private and public motor vehicles, from the ruinous and extremely injurious effects of vehicular accidents. So in order to secure the safety of the passengers and drivers at all times, the mandatory enforcement of the use of seatbelt devices by the drivers and the front seat passengers of private and public motor vehicles shall be enforced. For example, if you are driving a car and have a passenger sitting in the front seat, both you as a driver and the front seat passenger are required to wear seatbelt at all times. This law aims to reduce the risk of serious injuries or fatalities in the event of a collision or sudden stop. Failure to comply with the seatbelt law may result in penalties or fines. Next is the law on transportation of animals. So, by virtue of Republic Act 8485, also known as the Animal Welfare Act of 1998, it shall be the duty of any operator of any land, air, or water public utility transporting pets, wildlife, and other animals to provide in all cases adequate, clean, and sanitary facilities for the safe convenience and delivery thereof to their consigned at the place of confinement. So these animals shall be provided sufficient food and water while in transit for more than 12 hours or whenever necessary. No public utility shall transport any such animals without a written permit from Director of the Bureau of Animal Industry or his or her authorized representative. Any form of cruelty shall be penalized even if the transported has obtained a permit from the Bureau of Animal Industry. Cruelty in transporting includes overcrowding, placing animals in the trunks or under the food trunks of the vehicles. Next, let's proceed to the public service laws. Public service includes every person who may own, operate, manage, or controlled in the Philippines for hire or compensation with general or limited clientele, whether permanent, occasional, or accidental, and done for general business purposes, any common carrier, railroad, or street railways, traction railway, subway motor vehicle, steamboat or steamship line, ferries, and watercraft shipyard. But unless otherwise exempt, no public service shall operate without having been issued a certificate of public convenience or a certificate of public convenience and necessity. So for example, a bus company that offers transportation services to the public for a fee falls under the definition of a public service. To operate legally, the bus company must obtain the necessary certificate of public convenience or certificate of public convenience and necessity from the appropriate regulatory authority. So this certificate ensures that the company meets the requirement standards and regulations for providing safe and reliable transportation services to the public. So that's all with my discussion. Thank you and God bless.